Picture this. It's 1999. NATO bombs are falling on Yugoslavia. And in the middle of all that, something completely wild, something totally unprecedented happens. A legal battle kicks off at the highest court on the planet, the International Court of Justice. This wasn't just some political spat. This was a nation trying to put other nations on trial during an act of war.
And that really is the central question, isn't it? Can a nation actually be put on trial for waging war? And can a court really do anything about it while the bombs are literally still falling? Well, the case of Yugoslavia versus NATO tried to give us an answer. And let me tell you, it was a lot more complicated than a simple yes or no.
All right, so here's our game plan for breaking down this incredible case. We're going to start with the urgent plea that was filed right in the thick of the conflict. Then we'll look at the court's first really quick response, and then the second much deeper question that took 5 whole years to figure out. We'll have to untangle this bizarre puzzle about UN membership, check out the final ruling and the absolute shockwave it sent through the court itself, and finally, dig into why the way a court says no can be just as important as the answer itself. So, it all kicks off on April 29, 1999. The Federal Republic of Yugoslavia walks into the International Court of Justice and files a case against 10 NATO members, including Canada. The accusation? That these nations were breaking international law by using force, meddling in their internal business, and just stomping all over their sovereignty.
And this timeline, wow, it really puts the urgency into perspective. The bombing starts in March, and just a month later, boom, a lawsuit. But Yugoslavia wasn't just suing. They were demanding an emergency order to stop the bombing right now. The court gave a preliminary answer pretty fast, just a couple of months later in June. But the final, definitive ruling? That didn't come for another 5 years, long after the fighting was over.
So let's focus on that first round. Yugoslavia's immediate goal was all about one thing: hitting a legal emergency break. They wanted the court to issue what are called provisional measures, which is basically a fancy way of saying an injunction to stop the entire NATO campaign in its tracks while the main case was heard.
But, to get the court to do anything, first you have to prove it even has the power to get involved. That's called jurisdiction. So Yugoslavia came in with 2 big arguments. First, they pointed to a document they had just signed, literally days before, accepting the court's authority. And second, they argued the bombing campaign was a violation of the 1948 Genocide Convention, which is one of the few treaties that gives the court automatic jurisdiction. Yeah, but that first argument, it hit a wall. And it all came down to timing. See, the court just looked at the calendar. The dispute and the bombing began on March 24th. Yugoslavia's declaration accepting the court's authority wasn't signed until a month later, on April 25th. The court basically said, sorry, you can't apply this backwards in time to something that's already started. So that door slammed shut.
Okay, so what about the genocide argument? Well, that didn't work either. And the court's own words here are super clear. They explain that for something to be genocide, there has to be a specific intent to destroy a particular group of people. They essentially said, look, war is awful, and using force is destructive, but that in itself doesn't prove the very specific intent needed for a genocide claim. Without that proof, the court couldn't move forward. The request for that emergency stop was denied. Now, let's jump forward 5 years. It's 2004. The court is finally ready to give its final word. But the question they're answering now, it's not what you think. The whole game has changed. It wasn't about the bombing anymore, or the timing of a signature. It was about something much more fundamental.
And this was the killer question. Did Yugoslavia even have a ticket to get into the building? It's a legal idea called access to the court. Think of it like this. Before you can even argue your case, you have to prove you're allowed inside the courthouse. And for Yugoslavia, that was a huge problem.
So you might be thinking, why was this even up for debate? Well, it's because for the most part, you have to be a UN member state to bring a case to the World Court. And Yugoslavia's status at the UN back in 1999, oh boy, it was a mess. A total, complete mess. The court would later describe it with a very particular term, sui generis.
This is where things get really weird and confusing. Back in '92, the old Yugoslavia breaks apart. The new one, the Federal Republic of Yugoslavia, says, hey, we're still the same country, just smaller. But the UN comes back and says, no, you're not. You can't just continue the old membership. You have to apply all over again. So for 8 years, they were stuck in this bizarre legal limbo, not really in, not really out, until they finally got admitted as a new member in 2000.
And that's where this Latin term sui generis comes in. It literally means of its own kind or unique. The court used it because Yugoslavia's situation was so strange it didn't fit into any existing legal box. It was a complete one-off, a unique problem, and that had massive consequences for whether it could sue anyone in the World Court.
So all of this leads us to the big finale in 2004. The court is finally going to rule on this fundamental question of access. And the decision they hand down is, well, it's a real head-scratcher. It was completely unanimous, but at the same time, it basically tore the judges apart.
At first glance, it looks simple. The vote was 15-0. The court says, sorry, we don't have jurisdiction to hear this case. Unanimous dismissal. End of story, right? Wrong. This is where it gets crazy. In a pretty stunning move, 7 of those exact same 15 judges, that's almost half of them, signed a joint declaration saying, yeah, we agree with the final call, but we profoundly disagree with the legal reason the court used to get there.
So what was going on? Well, there were basically 2 different roads that both led to the same destination, no. The majority took this really complicated new path, ruling that because of its weird sui generis status, Yugoslavia just wasn't a UN member in 1999, so it couldn't access the court. End of story. But the other 7 judges were like, whoa, why are we making this so hard? Let's just stick with the simple, straightforward reasons from 1999. The case was filed too late and didn't meet the high bar for genocide. You might be wondering, who cares how they got there, as long as they all agreed to say no? But it matters. It matters a lot. Because in international law, the how is often just as important as the what. The legal path you choose can set new precedents and change the rules of the game for completely different cases decades down the line. So let's boil this all down. What are the big takeaways? First, international justice isn't a free-for-all. There are strict rules about who even gets to walk through the courthouse door. Second, the court gets to choose its own adventure, so to speak. It picks the legal reason for its decision, and that choice has real power. And as we saw, that choice can be super controversial, creating deep disagreements even among the judges. The how really can be more important than the what. But the court wanted to be absolutely crystal clear about one last thing, and it's a crucial one. They basically said, hey, just because we're throwing this case out on a technicality doesn't give a green light to what happened. It's this powerful reminder that even when the World Court can't rule, countries are still on the hook for their actions under international law.
And that's really the question that hangs over this whole affair, isn't it? The case was never decided based on whether the bombing was legal or not. It was stopped at the front door on a procedural issue. So it forces us to ask, when the highest court in the world can't rule, who can?